The Court of Appeals, Division 1 is now in session.
Please be seated. Good morning. This is the time set for argument in the case of Stasinski versus Coughlin et al. Our civil number 14-0401. Each side will have 20 minutes within which to present their arguments here this morning. Appellant may reserve some portion of that for rebuttal. However, it is up to you to keep track of your time in that regard. We have been through the briefs. We have been through the record. We're familiar with the case, the issues raised, and the arguments at least raised in the briefs. And we've conferenced this case already. So please keep that in mind as you make your arguments here this morning. We are recording the proceedings, both audio and video. So in case anyone wants to or needs to review this, please, as you approach the podium, identify yourself and your client for us. We'd appreciate that. With that, counsel, you may proceed.
Good morning. May it please the court, my name is Jay Jacobson. I represent Stanley and Patricia Stasinski, the plaintiffs and the appellants in this matter. One of the things that I would like to stress is that this case is for the most part a malpractice case, and it is a fundamental principle going back to law school that duty is a question of law. Breach of duty, causation, damages are fact issues for the jury, the trier of fact. And as I was preparing today, I was trying to come up with an executive summary of what I think the biggest legal error was. And that is, I think the trial judge ruled on duty, ruled on whether there's been a breach, whether there's causation, and whether there's damages. Before I even filed the lawsuit, I hired an expert witness, a lawyer, to determine whether the defendants in this case breached the standard of care. That is, that's not rocket science. We all know that you have to have an expert witness to sue licensed professionals. And suing a lawyer, I don't take lightly. So we hired our expert witness from Tiffany and Bosco, who came up with a 19-page report. I thought it was pretty scathing, and we felt comfortable proceeding. There was ethical violations, but the damages arise primarily from the legal claims. And the case against the Coughlin defendants really doesn't have much to do with the original easement and real estate transaction. For the most part, it has to do with the legal advice he rendered in subsequent years. And the legal question is not whether there's a valid easement or whether there's been full disclosure under this. It's whether he breached the standard of care. We have an expert report that says he did. And we have an expert report that says that caused damages to be determined by our experts, other experts. So we've hired other experts. We've hired a title insurance expert. We've hired a CPA. We've hired, others. But those are the relevant ones for this case. And they all felt comfortable rendering opinions as to what the damages are.
Well, counsel, are you telling us that in your view of this case, the fact that there is an operative easement, either the prescriptive easement or the quitclaim easement, that gives access to this property has nothing to do with the damage claims that you've brought in this case? Has no impact?
I don't think so. The question is whether these defendants breached the standard of care.
All right, you still have to prove damages.
You have to prove damages.
You have to show there's a genuine issue of fact as to the existence of provable damages.
Correct.
And what is that?
Well, you want me to address the damages, or?
I do.
Okay. Back when the, Jeff Coughlin is the one that drafted the easement, and you've read the reports about how he didn't disclose the prior representation of the client and get conflict waivers. He, our expert has said that he knew or should have known that the easement didn't reach the recorded easement didn't reach the property. I'd like to address the title insurance claim. The title insurance claim was not denied because the title was marketable or because there's actual access or an easement. It was denied on one basis, Your Honor, and that was it wasn't presented, the title claim wasn't made until after my clients no longer owned the property.
Yes, but you still have to show that if it had been timely made, it would have been honored.
Yes, and that's what Greg Milik, our expert, has said. If the claim, the title claim would have been made back in those years, long before there was published decisions in litigation, we had evidence, we had facts, we had surveys showing that the easement did not reach the property. We had witness testimony from someone that used to work at the county saying that they knew it didn't reach the property. And so if it had been made, the title claim back in 2006 or 2007 or 2008 or 2009, our experts are saying, yes, my clients would have received some benefits under the title policy, some defense possible benefits and some indemnity benefits. They could have paid neighbors for a recorded easement. They could have instituted a quiet title action and funded that.
Counsel, as I understand it, the Lawyers Title Insurance Corporation's policy insured for unmarketability of title and lack of access, but didn't specifically excluded things that didn't cause loss or damage. Okay. Is that a fair statement?
Your Honor, the record is not sufficient with respect to all of the I don't believe the title denial letters are in the record. That wasn't litigated.
Counsel, I'm only looking at the policy.
Okay.
And the policy is, the face of the policy is in the record.
We received a letter from Fidelity, Your Honor, stating why they denied the claim. It was one basis. I
understand that, Counsel, but just listen to my question. And if you would.
Yes, Your Honor.
The face of the title says, we will insure for unmarketability of the title and lack of access. We will not excluded or anything that does not cause loss or damage to the insured. Is that true?
Yes, I don't have the policy in front of me, but that is a standard title policy for those years.
Okay.
And title companies often, for a variety of reasons, raise coverage defenses, but they didn't raise any of those coverage defenses in this case. They only raised one, and that was the title claim was not timely presented. And then there's a new case out of the Arizona Court of Appeals that basically overturned. It was lawyer's title was actually the party, and it was the denial was similar to ours, and that was that you no longer own the property. The Arizona Court of Appeals, this division, I believe, held that this is the Centennial case, held that as long as you incur damages while you own the property, it's okay if you make the title claim after you no longer own the property. That was the holding of that case. So we represented the claim under the Centennial case, and they came back and said, well, basically, it wasn't timely presented, so we've been prejudiced because we could have instituted quiet title action and things like that. None of their coverage defenses ever had anything to do with whether the title was marketable or access. I think they agreed with us.
But
we persuaded them.
But to prove the malpractice case, as Judge Winthrop pointed out, you do have to, as Judge Winthrop, I think, pointed out, to prove the malpractice case, you have to prove that you would have lost, that you would have prevailed on the title claim. Yes,
and we have expert testimony. Greg Milik is our title expert.
Yes, but he did premise his opinion on the idea that you didn't have access to the property. Is that correct? Do you want me to pull out his, do you have his report in front of you?
I have. I'm very familiar with the report. It's a short one.
I would think you would be.
Yes,
but
Your Honor.
In my reading of the report, he makes it pretty clear, and everybody else who relies on it makes it pretty clear that Even though it appears that Mr. Coughlin never advised the Stasinskis, this is on docket 59, the affidavit of Gregory Milovich, is that what we're dealing with? Mr. Coughlin never advised the Stasinskis to make a title insurance claim, even though it appears that he knew or should have known the Stasinskis lacked a right of access. The Stasinskis in paragraph 6, the Stasinskis would have had a valid claim against the title company for up to $1.2 million because the title policy specifically ensures the right of access to and from the property. So his report that you rely on is based on lack of access. Is that right?
The title company,
I'm sorry, is that right?
you've read our report, right?
Okay, go ahead.
The title company was persuaded by our arguments, and they were ready, I believe, to concede that there was coverage at that point in time. Going back during those days.
Where would we find that in the record?
It's an affidavit from Stan Stasinski indicating the basis for the denial. There's only one basis for the denial. There's no other coverage defenses raised. It's Mr. Stasinski's.
Well, that comes back to your point that the denial that it was not timely, from your perspective, then excludes all other bases for denial. Is that fair? That's how you're reading it.
It's our job to persuade an insurance company to pay us money. And our experts have said that during that time period, this is before the published opinion, you can't, there's a lot of people and experts and government officials who believe there's no access to the property. We now have a published opinion, and we respect it. But that came out a couple months ago. If if the evidence and the witnesses and the affidavits would have been presented back in the relevant time period, the title company, according to our experts, would have paid money. Even though the Court of Appeals has disagreed on some of the arguments that we made back then. It was a matter of persuading the insurance company to pay money. And we haven't made a damage claim for the full title policy. We our experts kind of took a hybrid blend, assuming that there would maybe have been some attorney's fees incurred on a quiet title action, or some indemnity payments, possibly to buy an easement from a neighbor or something like that. And that's how we came up with the number. So we're not making a damage claim of $1.2 million.
I'm sorry, Counsel, I didn't hear that last.
We're not making a damage claim of $1.2 million. It's $150,000. So about 10% of the full policy. You know, maybe if a quiet title action had been instituted back then, there would have been a different result. Who knows? It depends on I guess, the judges and the evidence in the record before the court and defenses presented. So I don't think it is fair or right to use the published opinion from a couple months ago to go back retroactively and say you wouldn't have gotten any money because of the published opinion a couple months ago. Other than the opposing side in this case, it seemed like most people agreed that there were some problems with this easement.
With the recorded easement?
The recorded easement, yes. Okay. If Mr. Coughlin had disclosed to my clients, I'd like to address the damage claim related to the $300,000 Havens parcel. That's the next item of damages. The recorded easement doesn't reach the 13 acres that my client still owns. Okay. It is adjacent to the 1.2 million parcel because they're adjacent. The plan was that they would use the road and then drive to their neighboring property. They could grant themselves an easement someday when they got around to it. That didn't happen, and now he's stuck with a 13-acre parcel, and there's no recorded easement that reaches it, and even the Court of Appeals opinion has acknowledged that the adjacent property owners probably aren't bound by it. In other words, my client can't use that opinion in a seller's property disclosure statement to give comfort to buyers that they have an easement, because Trace Moore, the adjacent property owner, isn't bound. He was in a party, and he might disagree with some of the prescriptive easement holdings. So the Court of Appeals opinion applied as to the Lindalls, the sellers, but not to the adjacent property owners. So he still has a piece of property that's unmarketable, in our opinion, because there is a cloud on title as to the adjacent property owners who aren't bound by the Court of Appeals decision. If Mr. Coughlin had ever disclosed to my client in a timely manner, any time prior to him buying the $300,000 parcel, he wouldn't have bought it. He wouldn't have bought it if Mr. Coughlin had disclosed that there was problems with the easement didn't reach the property, that he previously was involved in negotiating the easement.
Isn't it clear that you're talking about the recorded easement?
The Havens parcel, okay, the Havens parcel my clients bought for $300,000 in 2007. That's an element of our damage claim in this case against the Coughlins.
Right, and your argument is that it's clear that the recorded easement on its face has nothing to do with the 13 acres.
Correct. It never reached it. It reached the adjacent property that he used to own.
But it has nothing to do with it. If there was any defect, it was a defect as to the 431 and 10 acres.
Well, the road would have been over the 431 acres and then next door to his 13 acres because he owned the two properties together.
Right.
And he ended up losing one, and that he was relying on that easement to get to the 13 acres, so now he has no easement.
But the recorded easement had nothing to do.
Yeah, that was the same route that they were going to travel.
Excuse me?
That was the road that they were going to travel to get to the 13 acres. But it didn't reach the 431 quite. But once he was on his property, there's roads on his property that go to the 13 acres.
Okay.
Yeah, they were adjacent, so by there's a wide variety. He just grants an easement for himself. He owns both properties.
If I understand it right, the theory is Mr. Coughlin didn't disclose defects with the recorded easement.
Yeah.
Right. Okay, that's the theory.
That there was no easement.
The recorded easement on its face has nothing to do with the 13
Basically,
acres.
the recorded easement is 95% of the road that gets to the 13 acres. There's no different road. That's the bulk of the road.
So you're saying without the recorded easement?
You can't get to the 13 acres.
Without the recorded easement, the 13 on its face, even though it doesn't apply to the 13 acres, that it still is important for the 13 acres?
He needed the recorded easement to get to 13 acres. That was about 95% of the length of the total road to get to the 13 acres. He would get onto his 431 acres and then drive next door. So there wasn't a need to get a separate easement because he owned both properties. In other words, when you're buying a property next to a property you already own, it's not an issue to have an easement because you can grant one to yourself at that moment. He hasn't done that, and he didn't do it in time, nor was he advised to do it in time before the foreclosure. So now he can't grant himself an easement anymore. So that's where we're bringing a claim for the $300,000. I'd like to address then the foreclosure matter. Mr. Coughlin was specifically hired to handle the foreclosure, and he called and made calls on behalf of the Stasinskis to the bank.
Let me ask about that. That's just troubling to me. Is there anything in the record that says, and where is it if it does, that says, but for what Mr. Coughlin did or didn't do, your clients would not have gone to the bank and entered into that agreement? That because, in other words, because he didn't do something or did something wrong, they went to the bank and said, let's enter into this agreement.
Your Honor, our damage claim stems from the fact that if he had timely presented an objection to the foreclosure on the 10 acres, that letter would have been drafted differently. The bank had, yes, so our claim is that the bank's deed of trust only covered one parcel.
I know that.
Okay.
It shouldn't have covered the 10 acres, and that's the defect that you're talking about.
Yeah.
It shouldn't have covered the alleged defect that you're talking about. I understand that. But I kept looking to find something that said the only reason we went to the bank and entered into this non-deficiency agreement, okay, was because Mr. Coughlin failed to do what or either did something wrong in objecting to the foreclosure or failed to object to disclosure, and that's why we went to the bank. And I couldn't find that.
Okay. the scope of engagement focused on hiring Coughlin to make sure the bank did not take the $100,000 parcel, the 10 acres. Okay. And he never filed an objection in the bank or the foreclosure proceeding. And we have a ton of evidence in the record. Sandy Robledo, ex-employee of Country Bank, testified that it was her intention that the deed of trust only covered one parcel.
All of that.
We got some, I think, halfway decent admissions from Steve Burton of the bank, Stan Stasinski. And, you know, we know that when you're hired under I think it's the State Farm case as an attorney, unless you limit, you know, in writing the scope of engagement, everyone proceeds on the basis that, you know, the scope of engagement includes matters for which you generally have been hired to do. And that was the foreclosure, specifically the 10 acres.
Right.
And if he had filed an objection, see, Country Bank was pushing hard not to take that parcel out. And Coughlin did nothing about it. And
I understand all that, but I guess what I'm asking is,
okay,
where in the record can I look to find something that says that your clients went to the bank and would not have entered into this agreement with the bank if Mr. Coughlin had done something to stop the foreclosure?
Are you talking about the thing he signed on March 24th, the day before?
Yes.
He was hoodwinked into doing that. And he was hoodwinked into doing that. He was, I think, not understanding what he was signing. He had just gone blind in one eye. He's still blind today in one eye. It happened that he had just had surgery. But the main point, the evidence that is in the record, is he thought he had gotten an extension from Country Bank to postpone the March 25th foreclosure.
Right. But we're not talking about a suit against the bank. We're talking about a suit against Mr. Coughlin. So I'm trying to connect the dots of I'm going to assume Mr. Coughlin failed to do what he was supposed to do or did it wrong. Your client went to the bank the day before the foreclosure and said, let's enter, and entered into a non-deficiency agreement.
I'm glad he did, because
I understand that. Where in the record does it say, if Coughlin had done what he was supposed to do, I would not have entered into that agreement? I couldn't find that in the record. I kept looking for it.
I think it follows naturally from the course of events. The Country Bank was pushing to get the 10 acres. If Jeff Coughlin had filed an objection, the deficiency agreement would have been worded differently.
Okay.
And that kind of ties into the Sachs transaction. The reason he signed that is so that he could complete the sale with the Sachs. And he was having problems getting a hold of Coughlin. He left voicemails. This is the day before, the foreclosure. He thought he got an extension verbally from Steve Burton, and he was just gone blind in one eye. And he's signing a document that I think is a little bit confusing. Yes, it references two parcels up on the reline, but it doesn't really, it's not really clear what it's doing if you're not sophisticated.
All right, Mr. Jacobson, thank you.
May it please the Court, I'm Denise Wackles. I represent the Boyle-Petrich firm. Co-Appellee's counsel and I have agreed to a division of our time where I'll speak for perhaps 7 or 8 minutes if necessary, and he'll use the rest, and I have invited him to nudge me if I encroach on his time. The Court has actually anticipated most of the points that I had intended to make, so let me ask, are there some points that I could address that would be helpful to the Court? If not, then let me pick up on something that I heard for the first time here.
Well, I'm sorry. I would like to hear your, and maybe it's not your point to make here this morning, but Mr. Jacobson was saying that in response to Judge Kessler's question as to whether there was something in the record to prove that his clients would not have entered the agreement with the bank on the anti-deficiency matter, but for Coughlin's failure to do what he was supposed to do, and his point as well. It's an inference that you can draw. So I'd just like to hear a response to that.
I would be happy. Excuse me, Robert. You'll have to.
Oh, I was looking at him because Jeff Coughlin was practiced with the Boyle Petrich firm until May of 2007. The foreclosure was in 2010 after he had already left the firm, so that question is not connected to the firm's potential liability.
All right, we can wait then.
Oh, okay.
All right, go ahead.
I apologize. Well, the one point that I heard for the first time from appellant's counsel had to do with the relationship between the quitclaim easement and the 13 acres. You know, there's a finding in the Lindahl opinion that the quitclaim easement on its face does not apply to the 13 acres. Well, the whole genesis of the appellant's case against my client is there's something wrong with the quitclaim easement, and I am out the money I could have gotten through a title insurance claim, and I'm out every dime I paid for the 13 acres due to the defect in the quitclaim easement. However, when when appellants purchased the 13 acres in 2007, they had no expectation that the quitclaim easement was going to apply to that property. It was not in the chain of title. There's nothing to suggest that they could have ever been relying on the quitclaim easement for access to the 13 acres. So that's number one. But what Mr. Jacobson said today was, well, we were relying on it, the quitclaim easement, to get to the 413 acres and 10 acres, and once we were on those properties, then we got to the 13 acres. And if that's the case, then that's a harm that they caused to themselves, because they lost the larger part of the property due to their own conduct in defaulting on the $920,000 loan that they didn't pay back to Country Bank. So I agree with the Lindahl opinion that the 13 acres continues to have access via what was then known as South Muleshoe Ranch Road by prescriptive easement rights. But if hypothetically that were not the case, when a property owner landlocks itself, the law generally does not step in to assist. And so that would be our response to that position that I heard for the first time this morning. In terms of whether there was a loss, the one thing I didn't hear appellant's counsel mentioned is that appellants obtained a $920,000 loan on the 413 plus 10 acre parcels that they never repaid. So they essentially got most of their purchase money back by borrowing and not paying back. And I guess the claim fails against my client because, as one of you said, they haven't connected the dots. This case consists of unconnected dots, or the appellant's case consists of unconnected dots. Appellants did not have an economic loss while they were the owners of the 413 and 10 acre parcels. Under the facts as they unfolded here, which is that they lost it in a foreclosure, no one ever penalized them due to a defect in the quitclaim easement. They didn't fail to get the financing that they wanted due to the quitclaim easement. Simply, it was an unknown at the time that the larger property was in their hands. And by virtue of the memorandum decision in the Lindahl appeal, the alleged defect in the quitclaim easement has no impact whatsoever on the 13 acres that they continue to own. Unless there's any questions I could answer, thank you. Thank you all.
Oh, thank you.
Good morning, Your Honor. My name is Richard Chambliss. I represent the Coughlin appellees, and I'm going to address the question that Judge Kessler asked co-counsel first, and then go back and hit a couple of points on the two claims, the real estate claims and the title insurance claim, and then focus on the wrongful foreclosure claim. In response to Judge Kessler's question, which was, where is it in the record that there is any evidence to support an argument that Mr. Stasinski entered into an agreement with the bank, the deficiency agreement we call it, because Mr. Coughlin did or didn't do anything? And the answer to the question is there is nothing in the record to support that position. And in fact, that argument has not been made. You've asked the question, but it's not previously been addressed. The record is clear with respect to the statements of fact about what Coughlin did and, about what the appellants did, and they did it of their own volition. They went to the bank. They talked to I think the bank official, and Mr. Burton invited them to come to his office. And they had Mr. Stuzinski went to Mr. Burton's office, had a discussion on March 24th in which they talked about deficiency liability, $920,000 loan, $1,003,000 amount due, or $930,000 loan, $73,000 deficiency. Here's the deal, Mr. Burton speaking to Mr. Stuzinski. We will allow you to pay us $25,000. And if this property sells at a trustee sale for $930,000 or more, no deficiency. So 2 conditions to this agreement. The first condition is pay us $25,000. The second condition is the property has to sell for a stated price. And then goes on, that deficiency agreement letter says, if in fact the property is purchased at a trustee sale for more than $930,000, Mr. Stuzinski gets the benefit of that. The $25,000 that he's paid is going to be rebated to him if the property sold, for instance, for $940,000. Mr. Stuzinski would get $10,000 back. The point of the deficiency agreement is it was an agreement entered into between Mr. and Mrs. Stuzinski and the bank. Mr. and Mrs. Stuzinski did not seek the advice of Mr. Coughlin. Judge Kessler, that's not in the record because that wasn't what was my motion. That was the deposition testimony. But what did occur is they signed the letter. The property sells for $930,001. Both conditions are met. So this is that third claim, the wrongful foreclosure claim, is an attempt by the plaintiff to, as I would call it, have your cake and eat it too. Gets the benefit of the deficiency agreement, limits his deficiency liability, and one condition of that agreement is the 430-acre and the 10-acre parcel have to be sold at a trustee sale. Well, then he says, after I get the benefit of the agreement, I want to sue my lawyer for not taking action to enjoin the sale because I think I've got a claim to this 10-acre parcel that was surreptitiously attached to the deed of trust a couple of years earlier. Bottom line is the record is absolutely clear that when Stuzinski's went and signed the deficiency agreement, they'd already consulted with Mr. Coughlin about their position that the deed of trust was wrong by retaining the 430-acre and the 10-acre parcel. So they knew when they signed the deficiency agreement, the bank was going to foreclose on both parcels. They made their deal with the bank. They didn't meet with their lawyer about it. There is, I would argue, Judge Kessler, when you asked the question of counsel, where is it in the record? We supported our motion for summary judgment. If he had that evidence, it was his burden to come forward and say, here's the defense.
But is it a reasonable inference?
I mean, a reasonable inference based on what?
Well, I have a lawyer that I've engaged. It's a dispute of fact. I have a lawyer that I've engaged to try to stop the foreclosure or somehow avoid the foreclosure.
Right.
The day before, and he does or doesn't do things. And there's some disputes of fact. The day before the foreclosure, I go to the bank without consulting my attorney about what's happening.
Right.
And I agree with the bank to let them sell the 10 and 431 acres to avoid a deficiency.
Right.
Or a large deficiency. Is it a reasonable inference that because I asked my attorney to do something and there's no evidence that he did anything or he did it properly, or there is evidence he didn't do anything, or he did it improperly, that there was a reasonable inference that led me to go to the bank to enter into the agreement?
Not on the record before the court. And the response to that would be, there is no affidavit or deposition testimony by Mr. Stuzinski or Mrs. Stuzinski that says they consulted with Mr. Coughlin concerning this deficiency agreement. What is before the court is the deficiency agreement itself. It's a very simple, very straightforward document. And on the face of it, it says this is what's going to happen. We're selling the 2 parcels.
I understand that, but
Well, so I would argue, Your Honor, that if Mr. Stuzinski believed that Mr. Coughlin was going to do something, there should be a record that Mr. Stuzinski said, I better consult with my lawyer about this agreement because I've engaged my lawyer to go stop this foreclosure action. So the inference that the lawyer had some obligation to protect Mr. Stuzinski, when Mr. Stuzinski on his own enters into the agreement that requires the property to be sold.
I probably didn't word, maybe let me clarify the question. Is it a reasonable inference that because, assuming that Mr. Coughlin failed to try to stop the foreclosure or object to the foreclosure,
Right.
that led to Mr. Stuzinski going to the bank and entering into this agreement? Not that he consulted with Mr. Coughlin about the agreement, but that I expected my attorney to do something. He either didn't do it or he did it wrong, and I then went to the bank.
Okay.
Is that a reasonable inference?
I don't think that's a reasonable inference, Your Honor. Because they are mutually exclusive opportunities or remedies. For it to be a reasonable inference, what you're saying is Mr. Stuzinski had a reasonable belief that he could sign this very clear, simple deficiency agreement that had its conditions. He had a reasonable belief he could take the benefit of that bargain, save himself $50,000 in deficiency liability, and believe that his lawyer would then be doing something to take care of his problem. It's maybe a reasonable inference in a vacuum. It's not a reasonable inference when the backstage of it is this deficiency agreement. Have I answered your question, Your Honor?
In a way, yes.
Okay. Let me address very briefly the other 2 claims, and we have labeled those claims the real estate claim and the title insurance claim. And you've heard some argument on both of those, and one of the things that I would emphasize is with respect to the real estate claim, all of the things aside, you got to have damages. And the memorandum opinion on the Lindahl appeal establishes as an absolute fact that there were vested prescriptive rights to the 431 acres and the 10 acres. The appellant's own expert, Mr. Berthold, has given an opinion about damages. And Mr. Berthold's opinion about damages says the $1.2 million 431 plus 10-acre parcel, which was purchased for $1.2 million, is worth $1.2 million with an easement. And the memorandum opinion says there's vested prescriptive rights. There's an easement there. So there can be no harm. They paid $1.2 million. They got $1.2 million from their own expert's opinion. Similar testimony or similar opinion, Mr. Berthold, with respect to the 300 acres. 300 acres, Mr. Berthold said, with easement is worth $300,000. Without easement, zero. They paid $300,000 for it. The Lindahl appeal memorandum opinion says there's vested rights. So there are no damages. And all other things aside, whatever your claim is, you got to be able to prove damages. They have no damages. Regarding the title insurance claim, as we have set forth, title insurance is an indemnity policy. There are 2 general aspects that you get out of title insurance. If you get sued, title insurance company is going to hire a lawyer to take care of your problem. If you suffer a loss, title insurance company insures against that loss. So, Judge Kessler, you asked the question of counsel. You're reading the policy, and doesn't the policy require a loss or damage? Again, looking to the Lindahl opinion, which is the law of the case, Lindahl opinion says there's vested prescriptive rights for this roadway, and it's been there for 45 years plus. So there is no loss associated with the lack of access. One of the insured events is lack of access. That causes a loss or damage. It isn't simply lack of access. It's got to cause you some harm. It's got to cause you some damage. And the Lindahl memorandum opinion makes it clear there is 45 years of vested prescriptive rights, access to the 431 acres in the 10-acre parcel. So had a title insurance claim been submitted while they still own the policy, the response would be vested prescriptive rights. There is nothing in the record that would support even if you read the title insurance expert, who I can't pronounce his last name, Greg, even when you read his opinion, it says they might have a claim up to $1.2 million. Well, and then they argue, well, what they lost was the benefit of a lawyer that would represent them in a quiet title action. What they lost was the benefit of a lawyer establishing prescriptive rights. There's nothing in the record that says the title insurance company would have written a check and put money in the plaintiff's pocket because of this title insurance claim. And as the facts are abundantly clear, the title insurer would have done the same thing that the trial court did, which is look at 45 years of vested use of this roadway and say, okay, if we got to establish that, we will do so. But there is nothing that's going to put money in the pocket of the plaintiff vis-a-vis the title insurance claim. Since there are vested prescriptive rights, they've suffered no loss and no damage associated with that. Trial court got it right on all three of those claims. Trial court properly granted summary judgment, and I would urge the court to affirm the trial court's ruling. Is there any questions I can respond to?
Thank you, counsel.
Thank you.
We will take this matter under advisement.
I actually went back and found the evidence to respond to the question regarding the deficiency agreement. You were asking about what was in the record, and I dug through it. If I may have leave for 1 minute.
All right.
Thank you, Your Honor. Appendix 7 to our opening brief has Stan Szynski's affidavit, and I would refer you to paragraphs 18, 20, and 21.
Which affidavit? There were three
It's
of them.
Stan Szynski's affidavit of 10, 31, 13. It was filed in opposition to the Coughlin's MSJ on the foreclosure action. It's our Appendix 7.
Your Honor, that's also number 99.
It's record 99, right?
Okay, I've got it. And which paragraph?
Paragraph 18, 20, and 21. And I would like to read them briefly. Szynski say, at no time prior to the trustee sale in the foreclosure on March 25th, 2010, did Mr. Coughlin advise us that he believed the bank could properly foreclose on the 10 acres. Paragraph 20, at no time prior to the trustee sale in the foreclosure on March 25th, 2010, did we communicate to Mr. Coughlin that we decided to let both properties be sold at the trustee sale. Finally, paragraph 21, he states that, and he's talking about the deficiency agreement in the paragraph 21. He says, although the trustee sale was scheduled for March 25th, 2010, Country Bank had given us an extension beyond March 25th. Remember, he had a contract to sell the 10 acres offer. So we could finish our negotiations with a potential buyer. With respect to the letter from Country Bank dated March 24th, 2010, we signed, it was our understanding that when we signed it, the bank was also agreeing that the March 25th, 2010 trustee sale would be rescheduled to occur for a later date so that our agent, Connie Sue Class, could finalize negotiations on what appeared to be an imminent deal with the Sachs. We were not far apart. And finally, 3, after signing the letter and getting the March 25th trustee sale postponed to a later date, we found out that the bank did not honor the extension to the March 25th foreclosure date and had foreclosed on both parcels. And on the 25th, they sold to the Sachs. My client got an offer from. That's who the bank sold it to.
Mr. Chambliss, you still have a minute left of your time. With this additional information, do you wish to comment?
Your Honor, my response to that, and I appreciate the time to respond to it. My response to that is that those facts don't support the question that was asked by Judge Kessler. And the argument that Mr. Stuzinski had a hidden belief that he could enter into the deficiency agreement and then still maintain the right to sell the property to Mr. Sachs is refuted by the plain language of the deficiency agreement and the law that was argued at the trial court at the summary judgment motion, which is you're bound by the terms of the agreement. You can't look at the agreement and say, I agree to sell the property, and then say, I have a hidden belief that I'm going to be able to sell the same property to somebody else the next day. And therefore, his affidavit, which attempts to create a question of fact, which is directly refuted by the deficiency agreement, you can't vary the terms of an ambiguous agreement. Thank you for the additional time.
All right, counsel, thank you both for your arguments here this morning. We'll take this matter under advisement and issue our written decision in due course. We're going to take a brief recess to allow the parties to come forward in the next case and get set up for the next argument. Thank you.